Hello, I'm Alan Todd. Recently, an artist on one of the Facebook art forums put up a question. If she was to make a study of another artist's work, would it get her into trouble? I guess she was asking whether it was even legal. The 50 pages of comments that followed suggested that neither she nor any of the respondents had ever read the Copyright Act or even understood it. So what I'm going to try and do today is to explain not only how it works, but in fact what the implications are in terms of penalties. The Australian Copyright Act of 1968, with later amendments, gives legal protection to an artist in any medium until 70 years after the death of the artist. And there are substantial penalties for breaching copyright in Australia. This means that the creator of the work is the only one who can decide how the work is used, and permission must be sought to do so. We are all aware of how this works, and a list of copyright infringements would include downloading music and movies without paying for them, using music in a public arena without permission, as happened at the Sydney Olympics and recent Trump rallies, using somebody else's photographs in a blog, and using somebody else's logo or painting or design in an advertising campaign. And Aboriginal artists in particular have suffered from this for a number of decades. It also extends to damaging the reputation of the copyright holder through use that is offensive. In recent times, it is social media that has created the most headaches in this regard. One person's offence is another's attempt at humour. All artists use the ideas and work of others and always have done. All art students copy and study the work of others and always have done. There are at least 12 versions of the Mona Lisa, mostly executed by Da Vinci students. However, in a more deliberate way, Roman sculptors copied Greek statuary and put their own names on it. And then there were the famous forgers. Van Meegeren and Betracchi produced thousands of fakes, many of which ended up in state collections. The estimate is that some 20 to 50% of all art in museums is fake. But the gallery directors may not own up to that, for fear of embarrassment that they couldn't tell the difference, or, I guess, for undermining the institution's value. Obviously, the problem is not the copying, but trying to sell it as the original artist's work. But there seems to be considerable confusion around this idea. Every time someone downloads a web page, technically it's a breach of copyright. Somebody owns the page and you haven't asked permission. Every time someone copies an image in Google Images, technically it's a breach of copyright. The claim is always that such things are in the common domain, and images stamped with watermarks is one attempt to get around this. Every time music and films are downloaded without payment, it is also a breach of copyright. However, tracing is legal, as long as the original artist does not object. Making fan art is not illegal, but selling fan art is. Making fakes or copies of paintings in itself is not illegal until you try and pass them off as originals. Some of this comes under the heading of fair use. The concept of fair use is widely quoted, but sometimes difficult to define exactly. What is fair use? In schools, students make extensive use of all sorts of copyrighted material for assignments, and at various times teachers have been able to photocopy sections of copyrighted material, documents, to add into lesson plans. Radio stations play music all day long, but they don't pay royalties. But then again, if the artists want their music heard, then radio stations do nothing to seek permission, they just assume they've got it. Students and teachers using copyrighted material is deemed as fair use, but the widespread downloading of music and films is not. However, policing all of this is near impossible. So what if your copyright is infringed? Well, the first thing you can do is ask the infringer to stop. But it hasn't stopped Donald Trump.
Your next option is to take the infringer to court. However, that isn't as simple as it seems. You may have to go to the country where the infringement took place, in that copyright laws vary around the world. There is some basic agreement between Australia, the USA, and Europe, but everybody else seems to have a different way of doing things. You can buy pirated copies of films and music in Asian countries. It's not illegal to buy them, but if you try bringing it back into Australia, well, it probably is illegal by that time. Then you have McDonald's currently suing Hungry Jack's. According to the case they're trying to bring, they are arguing about a similarity in word use. Big Mac and Big Jack apparently sound the same. All right, maybe they are. However, McDonald's is going to have to try and prove that it has suffered either financially or its reputation being ruined, and this may take years because in the end it comes down to a matter of opinion. But then again, McDonald's have got so much money they can throw at court cases, it's not going to stop them. It may come to nothing in the end. And what about going to jail? Well, it has happened. One unfortunate American woman was successfully sued and jailed for having downloaded 24 songs, but that was a long time ago. I would imagine the legal fees would have been astronomical. In essence, it's only large conglomerates that ever bother to sue anyone, and honestly, I'm not sure why they bother. The forger Van Meegeren, well, he died in 1947. His biggest problem wasn't that he'd actually painted all these fake Vermeers. His problem was in persuading the Nazis that he had. They simply didn't believe him. Well, he eventually went to prison. Essentially, you need a lot of money to be suing anyone, so only massive conglomerates ever bother. And as to how many of these cases ever get to court, well, that's a matter of opinion. There was a recent case involving the song Stairway to Heaven. It took years to resolve, and in the end, well, it didn't actually do anybody any good. There may have been similarities, but it certainly wasn't career breaking. The same was true of Men at Work and the flute solo. It could have been similarities in both cases, but proving it beyond doubt proved to be impossible. Donald Trump continued to use the music to which he did not have rights, even with all of those bands, including the Rolling Stones, telling him he couldn't do it. He just ignored them. The problem is that after the fact, there's nowhere to go. The offence has happened. And if you've got to prove that your reputation has been damaged, well, in the case of the Rolling Stones, a lawyer could argue that they did all that damage to themselves very early on. So the answer to the original question is that a reproduction of someone else's painting is perfectly legal, despite the words copyright being applied to it, as long as you don't try to sell it as the artist's original work. All of those exact copies of the Mona Lisa might have Da Vinci turning in his grave, but most of them were painted by his students and then given museum directors palpitations over time. Did those students breach copyright? In today's terms, possibly yes, but in Da Vinci's time it was standard practice to copy the master. In more recent times, a Brett Whiteley has been copied extensively. You talk about in the style of. No one can do it exactly the way that Whiteley did it, and it's accepted that, there's nothing wrong with trying to work out how he did what he did. His wife has recently catalogued all of his works. They are named and numbered and signed off by her so that in the future, if there is a question about the authenticity of a Whiteley, there is a catalogue to look at to find out what's true.
So what does all this amount to? Well, it's quite simple. You can make a study of a painting. There is no problem with that. And in fact, there is a paragraph in the Copyright Act that says, yes, you can. The problem comes when you try to sell that off as an original of the artist whom you've copied. That's a fake. That's illegal everywhere. It certainly doesn't stop people from doing it, and I'm sure there'd be another Van Meegeren just around the corner somewhere, intent on giving us another version of a Van Gogh or whatever. Some painters' work is easily copied, and we know that. But if it comes to prosecution, you've actually got to have committed an offence, and just copying a painting is not an offence, no matter what anybody on Facebook might say.